Small world, the world of informative flashcards. Flashcards in the Comprehensive Agrarian Reform Law, or CARL, Republic Act, No. 6657 Part 1. What is agrarian reform? Agrarian reform is the redistribution of lands, regardless of crops or fruits produced, to farmers and regular farm workers who are landless, irrespective of tenurial arrangement. Who is the father of agrarian reform, and why? President Diosdado Macapagal was considered the father of agrarian reform. It was during his term that the Agricultural Land Reform Code, or RA No. 3844, was enacted on August 8, 1963. This was considered to be the most comprehensive piece of agrarian reform legislation ever enacted in the country that time. What is the agrarian reform efforts under Marcos? The Agricultural Land Reform Code of 1963, ultimately amended in 1971, RA 6389, by the Marcos administration to become the Code of Agrarian Reforms, 1971 Code, sought to establish owner-cultivatorship or cooperative cultivatorship among those who lived and worked on the land as tillers. Land reform under Cory Aquino administration, 1986 to 1992. During the start of President Corazon Aquino's term in 1986, the Constitutional Commission approved Section 21 under Article 2, which states that the state shall promote comprehensive rural development and agrarian reform. This led to the drafting of CARP, which took the Congress a year to make. On June 10, 1988, Republic Act No. 6657, also known as the Comprehensive Agrarian Reform Law, or CARL, was passed to promote social justice and industrialization. Although it was still a product of adherence to democratic principles, this law was found to have many flaws. Because of much dissatisfaction with the agrarian reform law, proposals from peasant groups and non-government organizations grew in order to implement an alternative program that was more advantageous to them. However, this did not succeed. CARP recognizes not only farmers, but all landless workers as beneficiaries with the condition that they cultivate the land. The two main departments in charge of this program are Department of Agrarian Reform, or DR, and Department of Environment and Natural Resources, or DNR. Aside from the land distribution, it also provides the delivery of support services and security to the farmers. Under the Aquino administration, a total of 898,420 landless tenants and farmers became recipients of land titles and support services. Even with this, it can be considered unsuccessful because it only accomplished 22.5% of land distribution in 6 years. This was due to the fact that Aquino assigned 4 different DAR secretaries. The major setback for CARP was Aquino's Hacienda Luisida's stock distribution option, which says that she was the first landlord to evade CARP on a grand scale. Land reform under Ramos administration, 1992 to 1998. The policies on agrarian reform under the Ramos administration focused on accelerating the direct land transfer and non-land transfer through adopting more rational, fair and inexpensive settlements. It encouraged landowners to invest in rural-based industries that are connected to agriculture. It made an amendment to Section 63 of CARL to increase the fund of this project to $100 billion. Salaries of workers and members of DAR board were increased to motivate them for more successful results as well. The target land to be given to farmer beneficiaries under this administration was 3.4 million hectares, 4.7 million or 60% of which was successfully distributed. It achieved more than double the output of the Aquino administration. It focused on less contentious landholdings and acquisition modes, where they chose to work with autonomous NGOs and peasant organizations. However, controversies were unavoidable as they encountered landlords openly harassing peasants with guns and forcing them out of the lands. What law is Presidential Decree No. 27? Presidential Decree 27 is a law decreeing the emancipation of tenants from the bondage of the soil, transferring to them the ownership of the land they till and providing the instruments and mechanism therefor. Emancipation of tenants, October 21, 1972. Rice and corn tenants, 5 hectares, 3 hectares, 7 hectares. Land reform under Estrada administration, 1998 to 2001. This administration of Estrada focused on fast-tracking land acquisition and distribution. It wanted to reduce uncertainties in land market in rural places to help farmers' efficiency and private investment to grow. It encouraged joint ventures, cooperative, contact farming and other marketing arrangements to protect the status of stakeholders and promotion of agri-industrialization. They also improved the databases of the implementing agencies of DAR and DENR to fully record and update the lands covered. Estrada highlighted that there was a need to conceptualize new approaches in doing things to build a new social agreement where producers, government and private sectors work with a common goal. The program encountered some problems such as strong landowners' resistance. Tenants also complained on the limited amount of fund allocation provided by the government for the project. It aimed to complete 7.8 million hectares by 2004. Since President Estrada lasted only 2.5 years as president, the total beneficiaries of CARP was only 0.18 million or 10%. Comprehensive Agrarian Reform Program Extension with Reforms, or Carper. Comprehensive Agrarian Reform Program Extension with Reforms, known also as Carper or Carper, Republic Act 9700, is the amendatory law that extends again the deadline of distributing agricultural lands to farmers for 5 years. It also amends other provisions stated in CARP. In December 2008, the budget for CARP expired and there remained 1.2 million hectares of agricultural land waiting to be acquired and distributed to farmers. Carper was signed into law on August 7, 2009, by Gloria Macapagal Arroyo and was set to expire on June 30, 2014. However, the program of distributing lands to farmer beneficiaries continued even after June 2014. Section 30 of RA 9700 or Carper law states that cases on the matter which are still pending shall be allowed to proceed to its finality and be executed even beyond such date. Who are the beneficiaries of Carper? The beneficiaries of Carper are the landless farmers. B. Including agricultural lessees. C. Tenants. D. As well as regular, seasonal and other farm workers. In a certain landholding, The qualified beneficiaries who are tenants and regular farm workers will receive 3 hectares each before distributing the remaining land to the other qualified beneficiaries like seasonal farm works and other farm workers. Section 22 of Carl. The Department of Agrarian Reform, or DR, identifies and screens potential beneficiaries and validates their qualifications. Beneficiaries must be at least 15 years old, be a resident of the barangay where the landholding is located, and own no more than 3 hectares of agricultural land. The Carper law has bias for organized farmers to be beneficiaries because the Congress believes that the success rate of organized farmers is high and can make their awarded lands productive. What law is RA 3844? Republic Act No. 3844 is the Agricultural Land Reform Code, August 8, 1963, during the time of President Diosdado Macapagal. What law is Republic Act 6657? RA number 6657 is the Comprehensive Agrarian Reform Law, June 10, 1988, during the time of Quarry. This is the existing law. What is the scope of the Comprehensive Agrarian Reform Law of 1988? Section 4. Scope. The Comprehensive Agrarian Reform Law of 1988 shall cover, regardless of tenurial arrangement and commodity produced, all public and private agricultural lands, as provided in Proclamation No. 131 and Executive Order No. 229, including other lands of the public domain suitable for agriculture. More specifically, the following lands are covered by the Comprehensive Agrarian Reform Program. A. All alienable and disposable lands of the public domain devoted to or suitable for agriculture. No reclassification of forest or mineral lands to agricultural lands shall be undertaken after the approval of this Act until Congress, taking into account ecological, developmental and equity considerations, shall have determined by law the specific limits of the public domain. B. All lands of the public domain in excess of the specific limits as determined by Congress in the preceding paragraph. C. All other lands owned by the government devoted to or suitable for agriculture, and D. All private lands devoted to or suitable for agriculture, regardless of the agricultural products raised or that can be raised thereon. What was the schedule of implementation of Republic Act No. 6657? Section 5. Schedule of implementation. The distribution of all lands covered by this Act shall be implemented immediately and completed within 10 years from the effectivity thereof. What department of government is primarily in charge for the implementation of RA No. 6657? Department of Agrarian Reform, or DAR. What are the priorities in the acquisition and distribution of all agricultural lands? Section 7. Priorities. The Department of Agrarian Reform, DR, in coordination with the Presidential Agrarian Reform Council, PARC, shall plan and program the acquisition and distribution of all agricultural lands through a period of 10 years from the effectivity of this Act. Land shall be acquired and distributed as follows. Phase 1, Rice and Corn Lands under Presidential Decree No. 27, all idle or abandoned lands, all private lands voluntarily offered by the owners for agrarian reform, all lands foreclosed by government financial institutions, all lands acquired by the Presidential Commission on Good Government, PCGG, and all other lands owned by the government devoted to or suitable for agriculture, which shall be acquired and distributed immediately upon the effectivity of this Act, with the implementation to be completed within a period of not more than 4 years. Phase 2. All alienable and disposable public agricultural lands. All arable public agricultural lands under agroforest, pasture and agricultural leases already cultivated and planted to crops in accordance with Section 6, Article 13 of the Constitution, all public agricultural lands which are to be opened for new development and resettlement, and all private agricultural lands in excess of 50 hectares, insofar as the excess hectareage is concerned, to implement principally the rights of farmers and regular farm workers, who are the landless, to own directly or collectively the lands they till, which shall be distributed immediately upon the effectivity of this Act, with the implementation to be completed within a period of not more than 4 years. Phase 3. All other private agricultural lands, commencing with large landholdings and proceeding to medium and small landholdings under the following schedule. Landholdings above 24 hectares up to 50 hectares, to begin on the 4th year from the effectivity of this Act and to be completed within 3 years, and b. Landholdings from the retention limit up to 24 hectares, to begin on the 6th year from the effectivity of this Act and to be completed within 4 years, to implement principally the right of farmers and regular farm workers who are landless, to own directly or collectively the lands they till. What is the provision of the law regarding ancestral lands? Section 9. Ancestral lands. For purposes of this Act, ancestral lands of each indigenous cultural community shall include, but not be limited to, lands in the actual, continuous and open possession and occupation of the community and its members, provided that the torrent system shall be respected. The right of these communities to their ancestral lands shall be protected to ensure their economic, social and cultural well-being. In line with the principles of self-determination and autonomy, the systems of land ownership, land use, and the modes of settling land disputes of all these communities must be recognized and respected. What is the procedure for acquisition of private lands? Section 16. Procedure for acquisition of private lands. For purposes of acquisition of private lands, the following procedures shall be followed. After having identified the land, the landowners, and the beneficiaries, the DAR shall send its notice to acquire the land to the owners thereof, by personal delivery or registered mail, and post the same in a conspicuous place in the municipal building and barangay hall of the place where the property is located. Said notice shall contain the offer of the DAR to pay a corresponding value in accordance with the valuation set forth in Section 17(18) and other pertinent provisions hereof. b. Within 30 days from the date of receipt of written notice by personal delivery or registered mail, the landowner, his administrator or representative, shall inform the DAR of his acceptance or rejection of the offer. c. If the landowner accepts the offer of the DAR, the Land Bank of the Philippines, LBP, shall pay the landowner the purchase price of the land within 30 days after he executes and delivers a deed of transfer in favor of the government and surrenders the certificate of title and other monuments of title. D. In case of rejection or failure to reply, the DAR shall conduct summary administrative proceedings to determine the compensation for the land by requiring the landowner, the LBP and other interested parties to submit evidence as to the just compensation for the land, within 15 days from the receipt of the notice. After the expiration of the above period, the matter is deemed submitted for decision. The DAR shall decide the case within 30 days after it is submitted for decision. E. Upon receipt by the landowner of the corresponding payment or, in case of rejection or no response from the landowner, upon the deposit with an accessible bank designated by the DAR of the compensation in cash or in LBP bonds in accordance with this Act, the DAR shall take immediate possession of the land and shall request the proper Register of Deeds to issue a Transfer Certificate of Title, TCT, in the name of the Republic of the Philippines. The DAR shall thereafter proceed with the redistribution of the land to the qualified beneficiaries. F. Any party who disagrees with the decision may bring the matter to the court of proper jurisdiction for final determination of just compensation. Who are the qualified beneficiaries under CARP? Section 22. Qualified beneficiaries. The lands covered by the CARP shall be distributed as much as possible to landless residents of the same barangay, or in the absence thereof, landless residents of the same municipality in the following order of priority. A. Agricultural lessees and share tenants. B. Regular farm workers. C. Seasonal farm workers. D. Other farm workers. E. Actual tillers or occupants of public lands. F. Collectives or cooperatives of the above beneficiaries, and G. Others directly working on the land. How many hectares is the distribution limit? Section 23. Distribution limit. No qualified beneficiary may own more than 3 hectares of agricultural land. Section 25. Award ceilings for beneficiaries. Beneficiaries shall be awarded an area not exceeding 3 hectares, which may cover a contiguous tract of land or several parcels of land accumulated up to the prescribed award limits. How to determine the just compensation of the land. Section 17. Determination of just compensation. In determining just compensation, the a. Cost of acquisition of the land. B. The current value of like properties. C. Its nature, actual use and income. D. The sworn valuation by the owner. E. The tax declarations, and F. The assessment made by government assessors shall be considered. The social and economic benefits contributed by the farmers and the farm workers and by the government to the property, as well as the non-payment of taxes or loans secured from any government financing institution on the said land shall be considered as additional factors to determine its valuation. What is the valuation and mode of compensation? Section 18. Valuation and mode of compensation. The LBP shall compensate the landowner in such amounts as may be agreed upon by the landowner and the DR and the LBP, in accordance with the criteria provided for in Sections 16 and 17 and other pertinent provisions hereof, or as may be finally determined by the court, as the just compensation for the land. What are the modes of compensation? The compensation shall be paid in one of the following modes, at the option of the landowner. 1. Cash payment. 2. Shares of stock in government-owned or controlled corporations. 3. Tax credits, which can be used against any tax liability. 4. LBP bonds, which shall have the following features. What are the incentives for voluntary offers for sale? Section 19. Incentives for voluntary offers for sale. Landowners, other than banks and other financial institutions, who voluntarily offer their lands for sale shall be entitled to an additional 5% cash payment. Section 20. Voluntary land transfer. Landowners of agricultural land subject to acquisition under this Act may enter into a voluntary arrangement for direct transfer of their lands to qualified beneficiaries subject to the following guidelines. A. All notices for voluntary land transfer must be submitted to the DAR within the first year of the implementation of the CARP. Negotiations between the landowners and qualified beneficiaries covering any voluntary land transfer which remain unresolved after 1 year shall not be recognized, and such land shall instead be acquired by the government and transferred pursuant to this Act. B. The terms and conditions of such transfer shall not be less favorable to the transferee than those of the government's standing offer to purchase from the landowner and to resell to the beneficiaries, if such offers have been made and are fully known to both parties. C. The voluntary agreement shall include sanctions for non-compliance by either party, and shall be duly recorded and its implementation monitored by the DAR. What is meant by agricultural activity? Agricultural activity refers to the cultivation and harvesting of crops, fruit trees, livestock, poultry or fish, and other farm activities and practices. What is meant by agricultural land? Agricultural land refers to the land devoted to agricultural activity and not classified as mineral, forest, residential, commercial or industrial land. What is meant by agrarian dispute? Agrarian dispute refers to any controversy relating to tenurial arrangements, whether leasehold, tenancy, stewardship or otherwise, over lands devoted to agriculture. What is meant by idle or abandoned land? Idle or abandoned land refers to any agricultural land not cultivated, tilled or developed to produce any crop, nor devoted to any specific economic purpose continuously for a period of 3 years. Ancestral lands refer to? Ancestral lands shall include, but not be limited to, lands in the actual, continuous and open possession and occupation of the community and its members. Are there lands exempted and excluded from RA number 6657? Section 10. The following are exemptions and exclusions. Of lands actually, directly and exclusively used and found to be necessary for parks, wildlife, forest reserves, reforestation, fish sanctuaries and breeding grounds, watersheds, and mangroves, national defense, school sites and campuses, including experimental farm stations operated by public or private schools for educational purposes, seeds and seedlings research and pilot production centers, church sites and convents appurtenant thereto, mosque sites and Islamic centers appurtenant thereto, communal burial grounds and cemeteries, penal colonies and penal farms actually worked by the inmates. Government and private research and quarantine centers, and all lands with 18% slope and over, except those already developed, shall be exempt from the coverage of this Act. Farm worker refers to. Farm worker is a natural person who renders services for value as an employee or laborer in an agricultural enterprise or farm, regardless of whether his compensation is paid on a daily, weekly, monthly, or pekya basis. The term includes an individual whose work has ceased as a consequence of, or in connection with, a pending agrarian dispute and who has not obtained a substantially equivalent and regular farm employment.